Good afternoon. Welcome on into another episode of From Day One. Let's hit the courtrooms with an interesting arraignment.
Supplemental 6 and 7, People versus Robert Winburn, 17654 FC.
Michael Doby for the people.
Camry Mish on behalf of Mr. Winburn, appearing from the Genesee County Public Defender's Office.
Along with Nathaniel Perry.
Okay, good afternoon. So we're here today on the adjourned motion to withdraw, and there is an order. We'll get to you, Mr. Winburn. There is a copy of the order that I entered on June 21st, 2019 that I wanted to have at my access before we proceeded last week, so I adjourned. And I did also look up the list that I have of prior attorneys for Mr. Winburn. Steve Tramonti, Deion Webster Cox, Susan Longsworth, Alexandria Taylor, Nicole James, Sam Bernstein, John Washington, Livingston County Public Defender's Office, and current counsel from Genesee County Public Defender's Office. So that is the eighth counsel. So I understand that you wanted to withdraw because there was a federal civil rights action filed against counsel. And so I forwarded a copy of my order that I entered where I enjoined Mr. Winburn during the pendency of the case from filing any complaint or grievance in this court with the Attorney Grievance Commission or any court against his appointed counsel until the trial of the case is concluded. And I provided that this order would toll any limitations period, and that he can file a motion in pro per to discharge his attorney only, and I would review that for good cause to determine whether his rights are being adequately protected and if it appears that counsel has been ineffective and whether a hearing is needed. So I'm going to give current counsel an opportunity if you want to make a record this afternoon.
Yes, Your Honor. We did receive that order. We reviewed it. And under federal law as well as state law, Your Honor can absolutely enjoin him from filing motions in your own court and can direct your clerk from not accepting motions that he files. However, a state court cannot enjoin a defendant from filing federal claims of civil rights, and he's not bound by that order in federal court, quite frankly. And obviously he's not because federal court has accepted it. So as such, we are now in a direct violation of both federal and Michigan Rule of Professional Conduct 1.7b, which makes us adverse parties to a client that we now represent. So that is the place that we've now been put in. There is 506 US 1, which talks about a defendant that was known across the country as being a nuisance litigant who filed lawsuits, civil rights actions, all sorts of different causes of action all over the country in all sorts of different courts. And the Supreme Court put limitations on what he could file, but they said that they could not stop him from filing. So essentially that's where we are. We can't stop him from filing these kinds of actions. You can hold him in contempt for violating your own order, but you can't stop him from filing federal actions outside of your own courtroom. There's no authority to do so, unfortunately.
Counsel, would you concede that you could take my order to the federal court and ask them to toll the litigation until this action is completed in this court?
We could request that of them, but they're not bound by it. We could try, essentially, but they're not bound by it. They don't have to. They don't have to do any of that. I would suggest to the court as a remedy in the interim. There's some Michigan case law, People v. Camerad, as well as some U.S. case law, Indiana v. Edwards. It gives some recourse to the court on what they can do with defendants that refuse to participate improper as they're supposed to, as the court tried to do with Mr. Winburn, and for what the court can do with defendants that refuse to cooperate with their appointed counsel. It gives the court direction, essentially, for what to do with that.
So are you going to file a brief with those authorities and the court?
Well, the Indiana v. Edwards and the People v. Camerad was more just a suggestion to the court for what the court can do with Mr. Winburn now. I can give those sites to the court, but I can file a formal motion to withdraw with the Michigan Professional Rules of Conduct cited as well, if the court would like me to.
Mr. Dobie?
Your Honor, I regarding the court's ability to enjoin or not, I have no additional authority to rely on. I do understand the position of the defense counsel the position Mr. Winburn has put the defense counsel in. Obviously, they need to follow the rules of professional conduct. Regarding their relationship and the breakdown there, I can add nothing.
Okay, thank you. So, Mr. Winburn, is there anything that you want to tell the court?
No, it's your turn, sir.
I think he's muted on his end, Your Honor.
I don't believe he's muted on our end.
Yeah, it might be something. I can see that he's talking, but it's not coming through.
Perhaps the Department of Corrections has him muted.
So someone is going to need to unmute it at your end, Mr. Winburn, because I can't read your pieces of paper, and this is your opportunity.
For the record, Your Honor, I did share with Mr. Dobie the lawsuit, the proposed lawsuit that he filed.
And I've been served now as well.
Oh.
By mail.
Can we get the defendant here?
Can you hear me, Your Honor?
Yes. Yes, I can.
Okay, I filed a motion to replace counsel on the 27th, fully articulating the details of these attorneys they've seen me for about 20 minutes and that's it. This is a capital case, right? So you can't keep blaming me and holding me culpable and tainting the record predicated on a single-sided self without ever even hearing from me what's going on, reading my documents. But I'm asking you to defer ruling until this motion. I filed it on December 27th. I mailed it first-class mail. I expedited legal mail. I got proof of mailing. I served it on these attorneys. I served it on their boss from the Michigan Indigent Defense Counsel system. I also served it on the federal judiciary, and I just brought another federal action against them. And fully detailing, this guy, Parody, has been a magistrate judge. He's never been a defense attorney. He's not even qualified, right? But long story short, this guy, he's got animosity towards me. He's threatened me. This is all in the body of the civil rights lawsuit. He's came on record, and it's on record, you were offering me a plea without ever even speaking to me in court on October 20th and August 22nd. That's on record, and I put that in my lawsuit against you, right? And then the polygraph mandate, in order for in order for me to get resources, I have to take a polygraph. That's not the standard. in a case, in landmark case, Miranda in California said that they are becoming state actors by limiting resources to the defense predicated on the requirement of a polygraph. And I told them I'll take a polygraph conditioned on if I pass their polygraph pertaining to my defense, then they can dismiss charges. But I'm not just going to freely take one, and they can't restrict and withhold resources from me. These people, this is a capital case. 20 minutes I've seen them since they've been on this, and before, this is on the record, before every court proceeding, they've never spoke to me. They never wrote me a letter. They've never accepted a collect call, Your Honor, and they never wrote me, there's been a complete lack of communication. So you can't attribute this to me for me saying what I'm entitled to under the Sixth Amendment. And that's why I sued them in federal court for declaratory and injunctive relief. I'm not, and you keep trying to taint and distort the record here that I'm being unreasonable. I'm not being unreasonable. I'm demanding what I'm entitled to. What capital case? Think about this. 20-minute interview. These guys were ready to go to trial and hang me. And that man threatened me in the background, Perry. And he knows it. He knows it. And Tammy, and I'm asking, let me put these guys under oath and ask them some questions. Is it true? Yes or no? Have you ever visited me? And ever once? Never. Have you ever wrote me a single letter? Not one. Not one. Right? This is America. Right? This is what you took an oath to defend, and the judge has suspended my right of self-representation. Right? I'm emotional because you're trying to hang me and not accord me any due process at all. My motion, though, and this is so important, my motion fully articulates, I sent this to the court, motion to replace counsel and to afford me due process. And then for my own attorneys to come into this proceeding and not defend my interests when the court is, because they're advocating contempt against me. You heard her in her argument. That's a clear breakdown in conflict of interest, self-interest on their own behalf now. It is not created by me. It's because I complained about their systemic ineffective assistance to counsel. Not a single visit in a capital case, not a single collect call, not a single motion on my behalf. And the court has suspended my right of self-representation because I'm articulating these things. It's been 3 years since the court has took away my right to self-representation. And there's a dispute, a material issue of fact, a dispute, whether or not that order was lawful. And one day that's going to be challenged because this standing order depriving me, an American citizen, of my statutory common law and constitutional right of self-representation it's guaranteed to me. And it can't be a blanket denial forever, suspension. It can't. Not in America. You can do this in a third world country, but you can't do it in America. But my motion, it speaks to that. And I'm asking the court, at a minimum, review the contents of this motion. I mailed it on the 27th. I was hoping it was placed on the docket today before this hearing, but I served them attorneys, and they cannot come up here and put them under oath. Have you ever visited me? Never once, right? Have you ever wrote me one letter? Not one. Have you ever accepted a collect call? Not one. And this case is on its way for a jury trial, and here's the thing. This is why it's so important. I showed them. Because I mailed, I'm doing my job. I'm sending them stuff. I got proof of mailing, everything. They know it. They've never challenged the issue of perjury, coaching, and the edited, redacted tapes, right? And that's the whole thing of this, is that the Michigan State Police, they cherry-picked it. It's all in my motion, quoted verbatim, exactly what's on the tapes. Exculpatory statements and absolute flagrant perjury. And my motion fully articulates it. Now, I'm not going to belabor the court and read it into the record, but the motion that is served, motion to afford due process and to replace counsel. The court will get this in a few days, or maybe after the new year, but it's in the mail. It's already been served. It's been served to my attorneys too, and I'm suing them. There's been some additional, and I'm adding an amendment to this today because my attorneys are now, they're not even defending me. You're threatening to hold me in contempt of court. But them cases and signs that I held up, they say if you're going to hold me in contempt of court, then one, I got a trial by jury on that issue. Plus, the court itself has to recuse itself. These are landmark U.S. Supreme Court holdings. And Perry's shaking his head back there. He knows he cannot. Have you ever once visited me? Never. Right? 20-minute Zoom visit, and that was where you were trying to force me to take a 7 to 20-year plea. And consistent with what you said on August 22nd on record and October 20th on record, without ever seeing me, you said I got a plea for you. I got a good deal for you. That's what you were doing. That's on record. You're on video. My family they've been burning DVDs on all this, right? And this is a conflict of interest of its highest order. How can this man, and you keep blaming me? Your Honor, you've got to look at and listen. Take the blinders off. Take the earplugs out. Read my plea. I prove that the prosecution is perpetrating a fraud on the court with false evidence. And these attorneys, they won't raise it because it shows that the court was involved in the actual perjury. Yes, it's in my 1983 suit in front of Judge Liebman right now. You know it. It's on record now. There's an electronic fingerprint of this forever. But here's the thing. I showed that in the co-defendant's trial, they let Stamps come in and testify under oath and say that she had an armed robbery conviction and that was dismissed as part of her plea. But this all goes right to that false narrative. It was not true. I got all the records because my attorneys wouldn't do their job, but I did my job. And it's fully articulated. And I'm declaring, swear me under oath, under penalty of perjury. That document that's been submitted to the federal judiciary and the one that's on its way to Judge O'Brien, it's on record. Your ineffectiveness is going to come back to haunt you. This is America. This is not North Korea. You should retire as a defense attorney and be ashamed of yourself. Because with the oath that you took, you just showed your allegiance to yourself over me. That cases I held up for the record, for video, they showed that if the judge is threatening contempt, I got a trial by jury on the issue, plus the judge herself has got to recuse herself. Remember, landmark U.S. Supreme Court holdings. These little unpublished opinions that you're trying to advocate to the judge from the Michigan Court of Appeals that I forfeit my right to be present because I'm objecting to this unconstitutional behavior by my own attorneys who are supposed to be defending me, and they're defending their own integrity and their own interests over mine now. But that's why I sued them in federal court. And, Your Honor, I'm asking you to please review the contents of my motion. I show you this whole case is built on fraud and perjury and the electronic evidence. My attorneys will not transcribe what's on the DVDs, on the tapes, because they're just letting the prosecutor run the self-serving statements that are on the state police reports. But the state police recordings of the interviews that are not self-serving, Michael O'Connor repeatedly exonerated me and said that it wasn't me. He never heard the voice before, right? And these attorneys will do nothing about it. This is a fraud of its highest order. And this court took Nicole Stamps' guilty plea from her. The court knew, when taking her guilty plea, that she only had 2 charges. But this court let her go into co-defendant's case, and them 2 charges she had was only home invasion and conspiracy. Yet she testified under oath that was elicited by the prosecution, and They specifically asked her, did you have an armed robbery? Yes. She testified under oath to that. They got an ethical duty. That was a fraud, but it was part of their narrative to paint the picture that, and to be cohesive with the statement that there was a plan of armed robbery. And they're trying to use this to establish a link and put me at the front door of Michael O'Connor's home in order to bolster this fake armed robbery narrative that Nicole Stamps was allegedly a part of. But if they look at the electronic evidence, look at it. Do your job as attorney. Have it transcribed. Because it's an exoneration. It's not an inculpatory statement, but the prosecutor methodically elicited that testimony, knowing it was false at the prelim to get a bind over, and then used that same perjury in the co-defendant's trial to try to build a false narrative against me. And the prosecutor's got a duty. I cite the case, People versus Wise, 425. Every defense attorney in the state of Michigan knows it. It says that if a witness committed perjury at the prelim, it's the prosecutor's duty to correct it at a trial. They are not doing it, and my attorneys are not forcing them to do that. And I cite the case that if a witness, Michael O'Connor and Nicole Stamps, are both commit perjury, the remedy is exclusion. These attorneys won't file a single motion on my behalf, not one. This case was headed to catastrophe, to a jury trial, after I articulated not a single visit, not a single motion, not a single phone call, not a single letter, right? Capital trial, Your Honor. I know that, and I feel, Your Honor, I cite the case, Amico. You're a witness now. You're a material witness because you let the prosecutor elicit from Nicole Stamps a fraud in the co-defendant's trial that she was convicted, or that she was charged with armed robbery, when that's not the truth. She was never charged. The prosecutor built that narrative in opening statement, elicited from her during trial testimony, and then hammered that theory in closing and rebuttal argument, right? And these attorneys want to sit on their hands and not subject the prosecution's case under U.S. versus Chronic to meaningful adversarial testing. That's the test. This is Gideon. I'm blowing Gideon's trumpet, and these attorneys don't know what it is. It's foreign to them because they forgot how to practice criminal defense because they're so used to pleading defendants guilty and rubber stamping them, right? This guy Perry, he's been a magistrate, and he was the administrative. What was you, state court administrator just shortly, or you still are, ain't you, on the website? State court administrator too? What, for Genesee County? Right? What kind of conflict of interest is that against criminal defense attorneys? Right? Look at your email. Yeah, you are ashamed. It's shameful what you've done to me. And you label me as an obstructionist. I'm not an obstructionist. I laid out and I indicted the prosecutor for using perjured testimony. All they got to do is have the transcripts made of the DVDs, because I listened to every one of them, and I got them. My family still got them, the 26 DVDs. I bet you ain't even listened to them, right? Yeah, keep rolling your eyes for the record, Cammy Mish, right? That you're rolling your eyes, right, and shaking your head yes. Yeah. That should be noted for the record, too. Disciplinary proceedings should be brought against you. And I promise I'm going to get a declaratory and injunctive order against you for conspiracy to deprive me of my civil rights. And advocating against me at this very hearing to have me excluded, that confirms what I said in the lawsuit. That's exactly what you told me you were going to do. And you just advocated that exact position for the record. Yes. And guess what? I invited Judge Matthew Liedman. I invited them to look, right, because the DVDs are coming. And you people are running a mock trial here, and this record should reflect. I filed a motion to replace counsel. The court should at least, at a minimum, defer ruling until they look at my motion. And the prosecutor, Mike Dobie, he should visit his Michigan Rules of Professional Conduct 3.8D violation here. because he's got an obligation to turn over exculpatory evidence. For him to allow Michael O'Connor to perpetrate a fraud, contrary to what he said on 911 call, on body cam to the first state trooper, and during his 1 hour interrogation with Detective Sergeant James Bunsu, he exonerated me. Every time the detective told him it was me, he said, nope, it wasn't Scott. It wasn't Scott Libby. He would know to go to the basement. How can you let him make a diametrical opposition and then testify under oath? Here's the key. This is the key to it. At the prelim, Michael O'Connor testified that this is what he told them. Right? This is what at the prelim, he said, this is what I told them, that I recognized the voice and I called 911 because of it. That's not what he told them. That whole thing was a fraud. But the police were, at first, they were using it because they had me charged with impersonating a police officer. Then that charge went away. They got rid of that because it didn't support their new theory that they were going to introduce by fraud and have him come in and say, no, I called 911 because I recognized his voice. And he sounded angry. That's a diametrical change as opposed to what was really said, but he testified under oath at prelim, and it's cited verbatim in this motion and in federal court. Exactly what he testified to, and this Perry's begging me to, you look at him shaking his head back there, he knows it, right? Because he ain't doing his job. If he did his job, he'd be raising these same points that I'm raising. And Perry, let the record again reflect. She's laughing and he's laughing. This is not a joke. This is a man's life and liberty and the Constitution and the prosecutor's ethical mandate. 3.4, they can't allow a witness to perpetrate a fraud, and neither can you, Your Honor, and you have a duty to control the proceedings and to ascertain the truth. You can't let them put together a falsehood and let Nicole Stamps and Michael O'Connor come in and testify falsely, and my attorneys certainly can't sit on the sidelines and say nothing and let them railroad me like this. Have the transcripts. They did nothing for me, Your Honor. Like I said, not a single visit, not a single phone call, not a single letter, nothing, right? They sat on their hands and have really failed to subject the prosecution's case to meaningful adversarial testing. That's the job of every good criminal defense attorney. It's the hallmark of advocacy. But instead of doing their job, they're now defending their own interest over their client and actually advocating for you to hold me in contempt of court. They should have asked for an attorney to represent me independently. If they feel that there's that kind of a conflict, I got a right to counsel on the issue of contempt of court and jury trial on the issue of contempt. That cases I cited for the record, can I please, since you said you can't read them, at least the case, that you can't read them when I hold them up by Zoom, but for the Court of Appeals, for the record, the case, the controlling case on the issue of contempt is Judge O'Brien you got to recuse yourself. Maybury versus Pennsylvania, 400 U.S. 455, 1971 landmark. And if you were considering holding me in contempt of court, this is what my attorney should be defending me on. But I got a right to trial by jury on the issue of contempt. In that case, is spelled CODISPOTI versus Pennsylvania, 418 U.S. 506, 1974. My attorneys are not defending me. I'm up here having to defend myself because they should be advocating that your enjoyment order is unconstitutional and you're crushing any and all dissent by effectively gagging me. What you've done, you put a stop order on all motions. You stopped me from self-representation for multiple years, right? For no reason other than the one claim that you attached yourself to. But in my motion, I break that down and explain why that your reasoning was wrong and why I've been being deprived of self-representation. But more importantly, too, is that in my motion I articulate that a new Supreme Court ruling came out, People versus Beck, and in July of 2022, and it said that if the court didn't comply with 6.417 MCR 6.417, when it declares a mistrial, right, that it had to do two things. It had to afford me the chance to suggest alternatives or to even give a objection. But as you know, the court threatened to have my mouth duct taped for me doing what I'm doing here, making a record, and you had me removed from the courtroom. But your order didn't say, I got the transcripts, it didn't say that the ultimate sanction would be removal from the courtroom. And you had me in an electric shock belt, Your Honor, and the Human Rights Commissions across the United States, I said that in my motion, they are all condemned and against putting prisoners in shock belts. You did that ex parte with Kimberly Napier in the lawsuit, right? And it's like you're doing so much to have me convicted and let these attorneys, it's in the lawsuit, read it. It's all in there, everything, right?
Oh, dude, you're boring.
And I asked the attorneys to submit as a matter of record, submit the lawsuit. I know your neck hurt.
Let's move ahead.
Put the two stories together, and these attorneys. But I asked my attorney.
14 minutes later.
The thing is that after they created that, then they use that as a trap to say, well, we're going to add new charges. I invite them to add new charges on that charge because the perpetrator or the person that was perpetrating the fraud is the same guy that like magic did the whole fraud in the beginning.
Fast forwarding.
Mr. Winburn, excuse me. You've been repeating yourself quite a bit. Is there anything new or different that you wanted to add? Because I do need to give counsel a chance to respond. So
yes, I'll sum up with
I'll give you a minute or two to do that.
Okay. There's a breakdown, total breakdown, attorney-client relationship and trust. These attorneys are advocating their own interests. This is not something that I created, Your Honor. This is me defending my liberty interest. And this is a constitutional right I'm asserting, the right to counsel or self-representation. You took it from me for over 3 years for no justification, retroactively going back. This is to be revisited every time. And if you would allow me to submit one motion, would you give me permission on the speedy trial argument in pro per? Let me submit it because I got brand new People versus Sharkey. I got a bunch of brand new cases, but
you can file a motion on that. That's a separate issue. If you want to file a motion, you've got. Or we'll have counsel to do that. So if you could just leave that part aside for today and deal with what has already been filed.
Yep. Well, my motion, like I said, I would defer to my motion and my civil rights lawsuit. I'm asking the court to take judicial notice of it under MRE 201 and 202, Michigan Rule of Evidence, that's pending against my attorneys. There's a breakdown and there's a conflict of interest of a structural magnitude, and these attorneys got a duty to me to withdraw from the case and to report to the Michigan Indigent Defense Counsel Commission Director this sham proceeding. And I'm going to get a copy of the DVD and have that burned and sent to the MIDC Director and also to the federal court as an amendment on your conspiracy to deprive me of my civil rights and to crush dissent and not defend me and not raise the issue of conflict of interest. And the court should recuse itself on contempt proceedings and my right to jury trial on the issue under the controlling cases. And my motion, I defer to that, and I ask for the court to make a ruling on my motion to replace counsel, not just on the attorney's self-serving request.
Denied, please.
Thank you. So a lot has been said. I will give Mr. Perry and Ms. Mish a chance to respond if they choose to.
Your Honor, we would agree that there is a breakdown. We don't respond to any of the other allegations based on the pending lawsuit and on the advice of counsel. We would just ask that you grant the motion. Thank you.
Okay. Mr. Doby, is there anything you wanted to place on the record?
No, thank you.
Okay. Well, I am granting the motion to replace counsel because they're really...
Because this guy is a fucking loon. Alright, with that, we'll bring the afternoon to a close. Come on back tonight for some more fun as we continue to march along here from day one. Have a great afternoon. We'll see you tonight.